So here's part 2 of our screencast on the 4 chapters, first 4 in the copyright text. The TEACH Act, the Technology Education and Copyright Harmonization Act. This one was created to provide rules for online education, and it allows the use of limited amounts of copyright protected material when used in qualifying educational situations. And that's something that us as online teachers here at UCA that we have to be very, very careful of. The Family Entertainment and Copyright Act. This is actually 4 separate acts. Artists' Rights and Theft Prevention Act of 2005, called the Art Act. It criminalized making recordings of motion pictures in movie theaters and releasing them before commercial distribution was in place. So you see the, piracy. I don't know if anyone has ever seen the Seinfeld episode where Jerry ended up violating this copyright law. Then there was the Family Movie Act of 2005. It legalized technology for private homes, allowing DVD players to filter offensive content as long as a copy of the video isn't made. So you, as a parent, can obtain technology, within your own private home that filters language and content. And I really, really wish that this would also be used in schools, but legally it isn't. Reauthorization of the National Film Preservation Board was the third part of this act, and then finally the Preservation of Orphan Works Act, which allows a library to make up to 3 digital copies for the purposes of preservation of an unpublished work, as long as the work does not leave the library. So that might be, something that a student has created, as long as it wasn't published anywhere publicly. And then penalties. The damages, there are actual financial damages, statutory set by law, can range anywhere from $740 to $30,000 per infringement. There's also innocent infringement, which is a different level, standard infringement, and willful infringement. So it depends on what level the violation is as to how much the financial damages are. And most copyright cases do end up settling out of court, but it is still very expensive. So liability is, for a teacher, the beginning of the chain of copyright liability usually lies with the teacher. There may be a technician. If the infringement is known and not acted on, that technician may be just as guilty. So maybe one of the tech people set up 2 VCRs, or DVD players, and they knew that a teacher was going to make copies of DVDs, or back in my day it would have been the VCR tapes. The librarian, this is the next step. Did you know? Did you provide in service? Can you provide documentation that you were not involved? And then it moves up to the principal. Typically they are also named in a lawsuit in a school. And district policy regarding copyright and copyright violation may result in the loss of a job. So you need to look at contract law, privacy statutes, trademark laws. But, a lot of us talked about, or you guys talked about, just putting even a sign over a copier that just says, any violations, just know that if you violate copyright law, you are the one responsible. And that typically does take care of it. So Chapter 2 moves into public domain, and I focus specifically on pages 27 through 30. A work is not protected by copyright, and it may not qualify for copyright if it's not creative or not created by a human. If the copyright has been lost, that means the term had been ended and, it wasn't a renewed copyright. Or, if something is dedicated to public domain upon creation, then, it's not protected by copyright. And copyright can't be renewed once an item has lapsed into public domain. Original versus adapted falls under this umbrella. Something is in public domain, then it may be reproduced, adapted, distributed, performed, displayed, and transmitted. And you can check out the website pubdomain.com if you're interested in anything that does fall within the public domain. Copyright free does equal public domain. Royalty free means that something is still protected by copyright, but the author is not collecting royalties for the use of the material. And then license, that is items that you have to pay for use. Royalty-free items are governed by license, so that might be art or music for productions or publications, different images and things that you could use, or music that you could put within, some type of presentation. Chapter 3. This one, I really just kind of broke it down to pages 31 and 32. Licensed and royalty-free materials. Creative Commons license, if you want to check out that website, it hopes to benefit scholarship and society, and there are 4 different types of license for this. Attribution, a lot of times you just need to attribute the original work to the original author and not say that it's yours. Sometimes a Creative Commons license will say that it's a share-alike. You can distribute derivative works only under a license identical to the license of the original. Non-commercial, others can copy it, the copyright work and derivative works, but only for non-commercial purposes. So if you're not selling your students, the stuff that you're handing out, then you should be okay there. Or there could be a 4th one, no derivative works. You do what you want with the original, but you can't create other works from that original. And there are 4 Creative Commons tools. You have public domain. That means the author claims no rights to the work. You also could have the author licenses the work with free software foundations. Within the GNU, it's a public license as well as Creative Commons metadata and deed. You also have the CC/GNU GPL, so that one is also, it's just like the one right above it, but this is just for software. And then you can also have the Berkeley software distribution. Author licenses the work under the open source initiative. BSD license as long as the author is not used to endorse or promote the product derived from the original. And Chapter 4, fair use. This one, Chapter 3, I just kind of went through very fast. It's very complicated. Just know that you need to pay attention for those Creative Commons licenses. Chapter 4, though, this is more the meat and potatoes to me, how schools and teachers and school librarians can use things, is if you look at fair use. And this was on pages 35 through 46. So the exception to the copyright law is defined by fair use. There are some things that apply to all people and some things that apply to some environments of use and things that apply specifically to school libraries. So the 4 factors, you need to go back to the purpose and character of the use, including whether such use is of commercial nature. If you're trying to sell it, or it's for or is it for that nonprofit educational purpose? That seems to be the deciding factor. The second is the nature of the copyrighted work, and we'll get into that in just a minute. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And finally, the effect of the use upon the potential market or value of the copyrighted work. So factor 1. Purpose and character of use. You need to meet at least one of these sub-factors. Nonprofit educational use. Are you in a nonprofit school and considering using it for that institution? Second, criticism, commentary, news reporting. Are you using portions for those 3? So typically most of us are in that nonprofit educational use. Factor 2, the nature. If you have to meet both, it's preferred. Is it factual or creative? Using facts is better. And is it published or non-published? Unpublished is even more protected, so hopefully you found your stuff in a published place. The amount of work used, the essence. Does the segment embody the spirit of the entire work? If it does, then you probably need permission before you use it. And factor 4, the effect of the use on the market or the value of the work. Will it affect the commercial use? What would happen if every teacher were to use whatever it is that you're trying to use? Is it going to put that artist or author or whatever out of business? And to whom does this apply? Fair use applies to everyone. Some situations are considered more applicable than others, so shop for the fair use factors that fit. Guidelines were written by educators, not Congress, so just know that they may or may not be legal all the time. Schools versus libraries versus school libraries. School libraries benefit from both guidelines, but only for activities within your school library classroom. And school librarians are usually the only ones that receive this information during schooling, but they are not the copyright police. That has come up so many times in your discussions. Just know that we need to provide information, but we don't have to police all of it. That's not our job. But it is a good idea to talk to your administrators and see if there is some day or time when you can either share information, in a 1-hour workshop, or something. But schools kind of go through, and administrators, they kind of go through these cycles almost. Some years they pay a lot of attention to copyright, and other years they seem not to. But if you go back to our part in our course, I shared a couple of weeks ago a link to a movie licensing site. I realized I could go ahead and share it here. If you are ever interested, or you might want to share this with your administrators and let them see. But it's, to me, one of the cheapest ways to protect yourself. Enjoy your week.